Lawsuits based on negligence represent most of the civil cases filed in American courts. A person is negligent when his actions fall below a legally recognized standard of care, resulting in injury to another. All persons have duties to each other. Duties include conforming behavior to appropriate minimum standards. This standard helps protect individuals from unreasonable harm caused by others. This legal standard not only varies from state to state, it also varies depending on the type of negligence being alleged. To win a lawsuit against an allegedly negligent defendant, the plaintiff must prove four elements. The elements are duty, breach, causation, and damages. The first element of negligence is duty. A duty is an obligation imposed on all persons in society to exercise reasonable care in all of their dealings. Generally, the burden is on the plaintiffs to show that the defendants owed them this duty. If the plaintiffs cannot prove that they were owed a legal duty, then there can be no breach of that duty and therefore no recovery in a negligence claim. Certain individuals have a heightened duty of care to others. This means they not only have a duty to act reasonably, they also have a duty to protect and provide aid to others. The classic example is that of a parent and child. Parents owe duties to their minor children to not expose their children to unnecessary risk, and to take affirmative steps to protect them from unnecessary risk and harm. In many states, this type of duty is also imposed in other relationships. These relationships include employers to their employees, schools to pupils, hotels to guests, common carriers, like workers on buses, trains, or airplanes to passengers, and even jailers to prisoners. In the workplace, all states impose duties on employers to control their employees. Employers may be liable for the actions of their employees for their own negligence in carelessly hiring employees who commit negligence and harm other people. A heightened duty is also placed on professionals. Society expects doctors, dentists, lawyers, accountants, and other professionals to perform their jobs with skills superior to those of non-professionals. When they don't, malpractice may occur. The standard of care in malpractice cases is usually established by expert testimony of others in that profession, or by law or by industry standards. There is a special duty imposed on landowners. This duty is dependent upon the legal status of the person injured on the land. If injured people enter the land with permission, they are categorized as invitees or licensees. People on premises without permission are trespassers. An invitee is owed the highest duty of care. A business invitee is a person who's on the land to conduct commercial transactions. For example, customers dining at restaurants are business invitees. A public invitee is a person on public land or land held open to the public. Park goers, for example, are public invitees. A landowner has a duty to take reasonable care to prevent injuries to any invitees on their premises. This includes a requirement to frequently inspect the land and ensure that it's safe. This is why department stores and grocery stores often employ risk management associates who monitor the premises looking for possible dangers to customers. A licensee is also owed a duty of care by the landowner, but not as high as that owed to an invitee. A licensee is a person on the premises of another for non-commercial purposes. An individual attending a party at the home of another, for example, is likely a licensee. Landowners owe licensees a duty to warn them of known concealed dangers on the property. An example of a concealed danger would be a loose step on the porch or a very slippery walkway that is not obvious to the visitor. Unlike the duty owed to an invitee, a landowner does not have the responsibility to inspect for undiscovered hazards. A trespasser is someone who enters the land without permission. Trespassers are owed the lowest duty. In fact, virtually no duty is owed to unknown trespassers. Most states, however, impose a duty to known or foreseeable trespassers to warn them of known artificial dangers on the property. So while there's no duty to warn of natural dangers, such as lakes or poisonous plants, the homeowner may not place booby traps or electric fences in places where there are foreseeable trespassers without at least warning them of the danger. Many states impose a special duty on landowners to protect trespassing children. Trespassing children may get the same protection as a licensee or invitee if there is an attractive nuisance on the property. An attractive nuisance is a dangerous artificial condition that may attract children. There is a duty to exercise reasonable care so as to avoid harming the trespassing children. Common examples of attractive nuisances include swimming pools, playgrounds, and even construction sites. Therefore, the landowner would have a responsibility to place a fence around a swimming pool, for example, that would keep children out. A sign warning the children to keep out may not suffice, since it's foreseeable that some children could ignore it. The second element of negligence is a breach of duty. If a legal duty is owed and the first element is satisfied, then the plaintiff must show that the defendant breached that duty. A breach occurs when the defendant's conduct falls below that of a reasonably prudent person. The reasonably prudent person is, of course, a fictitious creation used to measure whether certain behavior is too risky. Courts ask, would a reasonable person have behaved in the manner that the defendant behaved if faced with a similar situation? If the answer is yes, then the defendant did not breach his duty. The third element is causation. Causation links the defendant's breach of duty to the plaintiff's injuries. The causation inquiry asks whether the party should be held responsible for his actions and the injuries these actions produced. Causation is broken down into two categories: actual cause, or quote-unquote but-for cause, and proximate cause. To recover, the injured party must prove that the defendant was both the actual cause and the proximate cause of the injuries sustained. The actual cause can normally be determined after conducting a quote-unquote but-for analysis. But for the defendant's actions, would the accident have happened? This is a very straightforward inquiry and rarely leads to uncertain conclusions. A defendant, however, may not be held liable for injuries caused by events that he set in motion once the injury is considered to be so remote from the negligence that the negligence is no longer considered the proximate cause of the injury. Even if a defendant set events in motion, he may not be responsible for the injury if it was too remote from the negligent behavior. Typically, situations where responsibility has been cut off due to lack of proximate causation occur when other unforeseeable events, such as weather phenomena or the criminal acts of third parties that are outside the control of the defendants, contribute substantially to the plaintiff's injury. Let's look at one example. Let's say we have a character named Johnny Baseball. Johnny Baseball was negligently hitting baseballs in a public park one afternoon. One of the balls struck a woman walking through with her grandson on a pedestrian walkway. The impact of the ball knocked the woman unconscious. The woman is transported to the hospital, where it's determined that, though her injuries are not life-threatening, she needs emergency surgery. While awaiting surgery, a storm enters the area, and the hospital is struck by lightning, setting the top floor of the hospital ablaze. The woman suffers severe lung damage from smoke inhalation and dies 1 week later. While it's true that but for Johnny Baseball's negligence, the woman would not have been in the hospital on the day of the fire, Johnny's liability would likely be cut off by the lightning and subsequent fire that led to the injury that killed the woman. The injury that killed the woman was unforeseeable to Johnny, because Johnny could not foresee a lightning storm striking the hospital and setting the top floor of the hospital ablaze. Thus, Johnny is not the proximate cause of the woman's death and will not be held liable for it. The fourth element of negligence is damages. Damages are the measure of what was lost or damaged as a result of the defendant's negligence. To recover, the plaintiff must show that he suffered a specific harm or loss. Damages can include financial compensation for pain and suffering, medical expenses, lost wages, and property loss. Occasionally, a court may award punitive damages. Punitive damages are an amount over and above those damages due to the plaintiff that are based on compensation. The purpose of punitive damages is to punish a defendant and deter future negligent conduct. Punitive damages are usually only available, however, when the defendant engaged in extremely reckless conduct. Negligence is a very common cause of action and is the basis for most personal injury lawsuits, but can also be alleged in a wide variety of contexts, from medical malpractice liability to car accidents. Despite its broad applicability, any plaintiff alleging negligence lawsuits must prove these four elements to proceed and eventually recover.